You want to introduce us?
Power of balance of criminal trials is one facet which, as a student of law, lawyer, or a common man, would always like to understand. And also understand the nuances of the interplay roles of the judges, advocates, and investigators in this process. It was quite a fascinating topic, and therefore we requested Justice B.A. Patil, a former judge of Karnataka High Court, to explain the niceties of this particular topic so that we can deep dive into it and understand the nuances. Thank you, sir, for accepting our invite, and may our journey continue for knowledge sharing. Over to you, sir.
So, thank you, Vikas. Good evening to one and all. Distinguished members, my brother and sister judges, senior advocates, the persons from legal fraternity, junior advocates, law students. At the outset, I thank Sharath Law Chambers and senior advocate, trained mediator, Srimati Sushila Sarthi, who introduced and pushed me to take this task with the Sharath Law Chamber. And I also thank all who made me to learn something and made me a student today. I am overwhelmed before you to speak on this subject, the power balance in criminal trials. In criminal trials, balancing the powers between the prosecution, the accused, and the judiciary is essential for a fair and just outcome. This involves ensuring the prosecution has adequate resources to present its case while also safeguarding the rights of the accused, and that the judge acts impartially, weighing evidence and arguments to reach a just decision. Though we find division of power between each one entity, but system acts check and balance to prevent any one entity from wielding unchecked power. It also helps to check the degree of discretion vested with the judges. My friends, the vision document of this country, that is the Constitution of India, in its preamble intends to secure to all the citizens justice. Every citizen of this country is having a fundamental right to have unpolluted air, water, and environment. Like that, every citizen is having right to have unpolluted justice. Each entity wants to do justice to a cause. In justice delivery system, judges, advocates, investigating agency, prosecution, and other stakeholders are at intersection. Their main duty is to assist the court of law to come to proper, fair, and just conclusion to do justice to the cause. Justice is mankind's cherished desire. What is justice has been explained by Justice Warren A. Burger, former Chief Justice of Supreme Court of United States of America, while addressing the American Bar Association in the year 1984. He quoted, I quote, as a healers of human conflicts, the obligation of legal profession is to provide mechanisms that can produce an acceptable result in the shortest possible time with the shortest possible expense and the minimum of stress on the participants. That is what justice is all about. I unquote. In court of law, judges, prosecution, advocates, and stakeholders play distinct and vital roles to ensure that justice is administered fairly. Functions of each of these stakeholders is essential for upholding the rule of law and protect the right of parties involved in the case. It is said, judge and advocates are the two wheels of the same chariot, or two faces of the same coin, but they play different roles. In this society, if there is any problem, ultimate solution will be by the court of law. The main purpose of the law is to give safety to the person, property, and to protect their rights. Laws are divided mainly into two parts. One is substantive law, which defines rights of the persons and property, and the second one is procedural law, which prescribes the procedure. In substantive law, it is divided into two parts. One is civil law and another one is criminal law. In the both the laws, we find there is a breach of rights. In case of breach, if the remedy available is in the form of damages, compensation, or specific performance, it will be called as a civil case. In case of breach of right, if remedy is in the form of punishment, fine, penalty, then it will be called as criminal law. How to get the remedies in case of breach of right is going to be stated in procedural law. In procedural law, we find there are two types. One is civil procedure and another one is criminal procedure. So all the civil cases, civil procedure, and in criminal cases, criminal procedure is applicable. How much fact has to be established and proved before the court of law is going to be determined by Bharatiya Sakshi Adhiniyama, in word that we used to call it as Evidence Act. Now the old criminal procedure code has been amended and now it has been called as Bharatiya Nagarika Suraksha Samhita 2023. I want to bring to your kind notice some few facts. This act has come into force from 1st July 2024 only because of the reason that in the old code some lacunas were there, and in order to overcome such lacunas and to amend irrelevant part and give quick and speedy justice, this amendment has been made. It is said in Bhagavad Gita, Sambhavami Yuge Yuge, which means I manifest myself age after the age, or I appear in the every age. In that light, this new amendment has come into force from July 2024. So if you see the provisions of section 531 of the BNSS Act, it has stated two aspects. If any proceedings is pending investigation or trial, it shall be disposed of in accordance with the provision of the old code, which is called as CRPC. And after 1st July 2024, if any investigation or the trial starts, it will be made applicable. It makes it clear that prior to 1 July 2024, if any cases are pending, then we have to take the provisions of old CRPC. In criminal trial, power balance is important. If there is any mistake, the balance will tilt against him. In that light, judges, prosecutors, advocates, investigating agency, and stakeholders are having certain rights and duties to be followed. If you fail in discharging your rights and duties, there will be imbalance. With short introduction, we can discuss the matter in detail further. There is a maxim in criminal law: let 100 guilty be acquitted, but one innocent should not be. This maxim underscores the crucial importance of protecting innocent individuals from being wrongly punished. It closely tied to the principle that person is innocent until proven guilty. The guilt has to be proved in criminal case beyond reasonable doubt. If reasonable doubt remains, benefit will be given to the accused. The legal process is fallible and errors can occur. The power balancing of criminal trial acts as a safeguard against potential miscarriage of justice based on faulty evidence or procedures. In that light, we can take up certain procedural and other aspects for debate. This can be seen in every recent order passed by the Honorable Supreme Court of India in the case of a very film star, Darshan. In that particular case, the criminal balance has been done when the prosecution approached the Honorable Supreme Court, and therein all the aspects have been dealt, and if any irregularity and illegality has been done by even the court, so that can also be taken in issue, and that can be set right by criminal trial by balancing the same. In case of criminal cases, it will be set into motion by filing the report to the police by by filing the complaint to the magistrate. If you see the BNSS Act, there is no definition of the complaint. Complaint, it only refers to the complaint given to the magistrate. There are two types of offenses. One is cognizable and another one is non-cognizable. Where the punishment or the case is serious in nature and punishable with imprisonment for more than 3 years, and where the police can take the cognizance without warrant, then it will be called as a cognizable offense. And in case of non-cognizable, police cannot arrest without warrant, and it is punishable with imprisonment less than 3 years. And even in such cases, police cannot investigate without written orders from the magistrate. He has to make an entry in the book kept in the police station, and if in case if there are more than one offenses involving both cognizable and non-cognizable, it has to be considered as a non-cognizable case. Pauline Nariman, senior advocate of Supreme Court of India and a great jurist and a legal luminary, said, I quote, if you join as a lawyer or a judge, you are always a student of law, and one must keep his mind open to learn whether it is relevant or irrelevant. Advocate must sharpen their intelligence, and then only he will be a successful lawyer or a judge. Judge and lawyer must be quite acquainted with the principles laid down by the courts and rights and duties guaranteed under the Constitution. The basic principle of law says that you be just, you be remedium, which means where there is a right, there is a remedy. Preamble has also given us some basic structure, and in the said basic structure, it also gives fundamental rights. Under Article 21, it gives protection of life and personal liberty. Article 22 gives right to the accused to know the grounds of arrest and consult, and to be defended by a legal practitioner of his choice. He shall be produced before the nearest magistrate within 24 hours of his such arrest. In case of preventive detention laws, he shall not be detained for longer period than 3 months without authority of advisory board. Such order has to be communicated to the detainee forthwith. And under Article 20, it says no person shall be convicted of any offense except for violation of a law in force at the time of commission or the penalty which was in force at that particular point of time. It also refers to principles of double jeopardy. That means a person shall not be prosecuted and punished for the same offense for more than once. The main object is to avoid harassment by successive criminal proceedings. In the case of state of Jharkhand through SPCBI versus Lalu Prasad Yadav, two aspects of double jeopardy has been stated. One is atrophis convict and atrophis acquit. No person accused of any offense shall be compelled to be a witness against himself. It is nothing but self-incrimination. These protections are available when a person is accused of an offense and the judge lawyer, prosecutor, and the persons dealing with the case must know these basic aspects to balance the power which has been guaranteed under the Constitution. If there is any imbalance, there will be injustice to the cause and there will be breach of rights guaranteed under the Constitution. Immediately on receipt of the information of the crime, the role of the investigating officer is very important. Now, the new act gives power to the investigating officer even to take the assistance of experts at the place of incident or occurrence. That is, he can take the forensic experts to collect the evidence, doctors, and in case of if any digital evidence is to be collected, then under such circumstances, expert in digitalized computers can also be taken to the spot and he can collect the materials and from there that he can give better evidence. From all angles, the evidence has to be collected at the place of incident. Immediately, it helps in the trial. If you see the new Sanhita, it gives right to the arrested person that in case of non-bailable offense, he shall be informed that he is entitled to be released on bail and arrangement for the sureties. The person making arrest shall forthwith give the information regarding such arrest, place of the arrest to any of his relatives, friends, or such other persons disclosed by the arrested person. And an entry of such information has to be made in the book and he has to be produced before the magistrate forthwith. After production of the accused before the magistrate before whom the arrested person is produced, the court has to satisfy that the above said rights have been explained and have been given to the accused and he has been complied. In case of a search of a person of the arrested is done, he has to, that is, show the articles taken from the possession of the arrested person and he has to give a receipt for having taken the possession of such properties from the body of the person accused. In case of women, the search has to be done by another woman following the strict principles of decency. If you see section 50, it gives power to seize offensive offences. Immediately after the arrest is made, take from the person arrested any offensive weapons which were with him and immediately they have to be delivered to the court. Section 51 provides for examination of the accused by registered medical practitioners. If there are reasonable grounds that in examination will afford evidence as to the commission of an offense, he has to be examined without delay and forward the report. While examining, the doctor has to consider the following aspect: blood stains, semen, swabs and seed, hair samples, fingernail clippings by use of modern and scientific techniques, including a DNA profiling. In case of rape, the report has to be given in the prescribed form, so which has been mentioned in the act. The medical officer examines the arrested person and has to mention any injuries or marks of violence upon the person arrested, approximate time of the injuries or the marks. The report of the medical officer has to be furnished to the accused. I pause for a while and discuss with regarding to this. So if a arrested person, if he has been examined by the medical officers, so he wants to take any self-defense or any other, that is, defenses, then under such circumstances, if any injuries are found on the body of the arrested person, then under such circumstances, it will help. If that material or that evidence is not forthcoming, then under such circumstances, that it is very difficult for the accused to establish that he is he has acted under the self-defense. Even Section 54 of the BNSS Act, so it deals with conducting the test identification parade. Where a person is arrested, his identification by any other person or a person is considered to be necessary on request of the investigating officer that the test identification parade has to be conducted. In the case of State of Maharashtra versus Suresh, reported in 2000 Part 1 SCC, it is observed that the object of conducting the test identification parade is twofold. First one is to enable the witnesses to satisfy themselves that the prisoner whom they suspect is really the one who was seen by them in connection with the commission of the crime. Secondly, to satisfy the investigating officer that the suspect is the real person whom the witness had seen in connection with their said occurrence. Investigating officer has to satisfy that both the objects are satisfied in conducting the test identification parade. In the case of Shamuel Ghosh versus State of West Bengal, reported in 2012 Part 7 SCC 646, it is held that test identification parade is one of the circumstances which corroborate with other circumstances. In case of circumstantial evidence, the court has to examine with other attendant circumstances with reference to the facts of the case and decide the case on those facts. In case of noticing of any offensive, informant can intimate to the police or he may file a complaint to the magistrate. Earlier to BNSS Act, the information has to be given to the jurisdictional police. But now, irrespective of the area where the offense is committed, information relating to the commission of a cognizable offense may be given to the police. He has to enter the substance of such information in the book kept in the police station and register a zero FIR, and thereafter that within the stipulated time as stated in the act that he has to transmit it to the jurisdictional police. If the information given by the women for the offense of sexual assault is there, then the said information has to be recorded by a woman police officer. And in respect of the offenses under section 64 to 71, 74 to 79, or section 124 of BNS Act has been committed against temporarily or permanently mentally or physically disabled person, such information shall be recorded by the police at the residence of the person seeking to report such offense or at the convenient place of the reporting person. It must be videographed and a copy has to be given to the reporting person free of cost. If any police officer refuses to record the information, informant can send the same in writing personally or by post to the superintendent of police, or he can also file complaint before the magistrate. After taking such complaint, that he can also take the cause and send it to jurisdictional police for further action in the matter. If the information in respect of a non-cognizable offense, police officer has to enter the substance in a book kept in the police station. No police officer shall investigate without written orders of the magistrate. If he investigates, then it is considered to be illegal investigation. It can be quashed. During the course of investigation, police can examine the witnesses and record the statement. In criminal trial, the role of investigating agency is vital. He sets the cause in motion. If any defect occurs, then the foundation of the case itself will become weak and benefit of doubt will be given to the accused. If he files the B report before the court is also having a check and power to issue notice to the complainant, and thereafter that it can give an opportunity to the complainant to establish the case, and the cognizance can be taken on the basis of the evidence given by the complainant. In that light, the check and balances are also made in this particular act. Section 181 says, statement made during investigation shall not be signed by the person making it. It cannot be used for any other purpose. But if you see the proviso to section 181, it said it can be used to contradict the same to such witness when he has been examined before the court. An omission to state a fact or circumstances in the statement amounts to contradiction if the same appears to be significant and otherwise relevant, having regard to the context in which such omission occurs. Whether any omission amounts to contradiction shall be a question of fact. Section 181 is equivalent to old section of 162 of CRPC. In the case of V.K. Mishra and another versus State of Uttarakhand and another, reported in 2015 Part 9 SCC 588, how the previous statement of the witness has to be used has been stated. It is held that attention of such witness must be called to those parts of the statement used for the purpose of contradiction. While recording the deposition, it is the duty of the trial court to bring it to the notice of such witness in cross-examination by reproducing if he admits it is proved. If he denies having made such statement, then it has to be mentioned in his deposition, and when investigating officer is examined, his attention should be drawn to it and has to be mentioned in the deposition. It is also observed that if the witness was not confronted with that part of the statement with which the defense wanted to contradict him, then the court cannot suo motu make use of the statement of the police which is not proved. In this particular, that's a case. So what we that is find is, so here the attention of such witnesses must be called to those part of the statement. And what we have seen many a times, so here the entire statement of such witness is going to be marked and the same is going to be put to the investigating officer. That is not the purpose of the law. It is specifically stated, attention of such witness must be called to those part of the statement used for the purpose of contradiction. That part alone should be marked, and if he admits, then it is said to be proved. And if he denies having made such statement, then under such circumstances, that portion of the deposition which has been marked in the cross-examination has to be brought to the notice of the investigating officer when he has been examined before the court. Then that it is said to be proved, and the court can make use of the said contradiction. So in that light, so here that this particularly the balancing. So if any, that is prosecution fails to, then under such circumstances, a duty cast upon the court how to mark this particularly the document and how that particular part of the statement has to be used by the court for doing the justice. In criminal trial, there are two types of confession. One is judicial confession made before the magistrate, and the another one is extrajudicial confession. It is made before the other persons or the friends. One point has to be kept in mind. In case of extrajudicial confession, it is considered to be a very weak type evidence, and only on the basis of extrajudicial confession, court cannot convict the accused. It requires some corroboration. That is, clause has been also inserted in this particular regard. The corroborative evidence must be, that is, so linked that it connects to the accused. Under section 183, the confession statement can be recorded by the magistrate. One has to remember that it has to be recorded during the course of investigation before the commencement of the inquiry or the trial. After the trial, there is no question of recording the confession of the accused. Before recording also, there are certain guidelines which have been given. The magistrate who is recording the confessional statement he has to explain that he is not bound to make such confessional statement. He must also say that it can be used as an evidence against himself or him, and it is satisfied that it is made voluntarily, and before recording that the magistrate shall not detain the accused into the police custody, because any confession made before the police is not admissible, and in that light, so here this clause has been inserted that before recording he shall not be detained in the police custody. It shall be like examination of the accused, and after recording all the confessional statement, it must contain the memorandum of the magistrate at the end that all the formalities have been followed. So then only the confessional statement which has been made before the magistrate has to be, that is, accepted by the court. In case of recording of confession in sexual offences, that it has been stated that it has to be recorded as soon as possible, immediately after the commission of the offence, and it shall be by a woman magistrate. And if woman magistrate is not available in the presence of a woman, and it has to be recorded either audio, video, or by even a mobile phone. So here, advocate must also remember section 183 subclause 3. So here, whenever that the investigation is in progress, in case of offences punishable with death or imprisonment for life or 10 years or more, then under such circumstances, if the charge sheet has not been filed within 90 days, then under such circumstances, and in case in other than those cases within 60 days, then accused is going to get a statutory right of bail. And here the advocate must be very alert in counting the days and to exercise the right forthwith. And if he fails to exercise the right which has been accrued statutorily, then that the right is going to be extinguished, and fails, he will lose that particular right. So in that light, so here the balance has to be done by the advocate and the prosecution and the judge. Under section 193, after completion of the investigation, the final report is going to be given to the court. There are 4 types of cases which will come before the court: summary trial, summons trial, warrant trial, sessions trial. Before commencing any trial, it is the mandatory duty of the court to supply the accused copy of the police report along with all other documents produced along with the charge sheet. After filing of the final report, court, if it comes to the conclusion that it is trial by the sessions court, then the court has to commit the case along with all the records to the district court if it is triable by such court. And even district court is not having any power to call the committal case until and unless it is committed by the committal court. So here, while committing that, he has to send articles seized by notifying the same to the public prosecutor. After filing the charge sheet, the court has to take the cognizance of the case, and the case has to be posted for hearing before charge. At this stage, judge, advocate, and the prosecutor has to keep in mind the ratio laid down in the case of Surat Singh, Alwat, and others versus the state of Uttar Pradesh, reported in 2013 Part 11 SCC 476, wherein it has been observed that while framing the charge, court is required to evaluate materials and documents on record to decide whether facts emerging therefrom, taken at their face value, would disclose existence of ingredients to constitute the alleged offense or not. At this stage, the court is not required to go deep into the probative value of the materials on record. The accused is entitled to urge his contention only on material submitted by the prosecution, and no extra material has to be considered in this particular regard. If you see section 234, it speaks about the contents of the charge. Many a times what we see, the charge which is going to be framed by the courts is defective charge, or even the ingredients of the offences are not properly and clearly mentioned. In criminal trial, neither the prosecution nor the advocate appearing for the accused bothers with regarding to the framing of the charge. They feel that it is the duty of the court. Framing proper charge is very essential to prove the guilt of the accused, and accused must also know for what charges he has been tried and how to defend himself. In charge, it must state the offense, the law which creates the offense with specific name. If no specific offense is mentioned, the definition of the offenses, section of the offense, it must also state every legal conditions required by law to constitute the offense, separate charges for distinct offenses. It should be in the court language whether he has been previously convicted or not. It will help the accused to know with the precision what charges they are required to defend. This has been also held in the case of Vinoba Patil versus Ranjibhai Danoda Patel, reported in 2018, Part 7 SCC, for page number 743. It must also mention the time, place, the person against whom such offense has been committed, or the things against which the offense was committed. It must also state the manner in which it is committed and punishable with what section. At this stage, if accused pleads guilty for the offense, he can be convicted. But in case of sessions courts, so here the court has been given some discretionary power that it can reject the plea and proceed with the trial. Court has got power to alter the charge before the judgment is pronounced. If the charge is altered or added, depending on the circumstances of the case, court may direct a new trial if sanction is necessary till the sanction is obtained. In the trial will not be proceeded. If already witnesses have been examined, it may recall the witnesses and further examine. I pause for a while. So many a times, so already half of the witnesses have been examined, and thereafter that the charge is going to be altered. So here, if the advocate appearing for the accused, if he does not exercise his power to examine those witnesses, then under such circumstances that the balance will tilt against him and the accused may be convicted in this particular behalf. When for an offense, the ingredients of the major offense has been proved, though he was not charged with a minor offense, within it he can be convicted for the minor offenses. On the date so fixed, the prosecution may lead the evidence either by calling the witnesses to the court or through audio, video, electronic means. The judge is having a discretion to permit them to cross-examine. In most of the trials, the prosecution or the accused will not bother about bringing on record the circumstances to mitigate the sentence. They wait till the trial is concluded. If there is any presumption in law, or if any specific defense like plea of alibi has been taken, in that context also cross-examination has to be done. Advocate for the accused must know what to ask, what not to ask, how to ask, where to start and where to stop. If the witness has not supported the case of the prosecution, then unnecessary questions should not be asked to damage the case of the accused. Many a times that we have seen that what the prosecution has not proved during the course of the cross-examination, that the accused is going to prove the case, and on the basis of the cross-examination, in many cases, the accused has been convicted. In certain offenses, there are presumptions, like in a dowry death case, if a death has occurred within 7 years after the marriage, it is presumed to be a dowry death. In that light, advocate has to establish his case by producing rebuttal evidence on preponderance of probabilities. If there is imbalance in exercise of such power by the advocate for the accused will be convicted. If there is imbalance in power balancing by investigating agency or the prosecution, benefit of doubt will go or will be given to the accused and the case of the prosecution will fail. Here, an obligation is also there on the judge. In many of the cases by the Honorable Supreme Court, it has held that the judge is not a silent spectator or he is not an umpire. He must actively participate in the trial to do justice to the case. Even the statutory provisions under the BS Bharatiya Sakshi Adhiniyama, Code Section 165 of the Evidence Act, wherein that it has been stated, judge himself can put questions as court question to the witnesses or order for production of the documents if any that is material is required. So by going through all these provisions, so here that it makes it very clear that if there is any imbalance done by both prosecution as well as the advocate, then the court has to bring the balance by exercising the power which has been given under Bharatiya Sakshi Adhiniyama under section 168. My friends, in criminal trial, there are two types of evidences. One is direct evidence and another one is indirect evidence. In case of direct evidence, there will be eyewitnesses to the alleged incident, but in case of indirect evidence, the case rests on circumstantial evidence. In circumstantial evidence cases, one has to remember the maxim that men may lie, but the circumstances will not. So if all the circumstances that if they have been established, then under such circumstances, the chain of events is going to be proved and the accused is going to be convicted. As against oral evidence, document will also prevail. If there are any documentary evidences which establishes the presence of the accused, then under such circumstances that he has to be very careful. Nowadays, the digital evidence, especially the mobile phone, which is going to be used by the accused persons, so it will send the message where was the location of this particular accused at the time when the alleged incident has taken place. Then under such circumstances, both the prosecution as well as the advocate for the accused and judge has to, that is, keenly observe, and then the fair trial is going to be done. Apart from this, motive also has to be considered while considering the circumstantial evidence. Testimony of eyewitnesses, statement of injured witnesses, dying declaration, recovery of the articles used for the commission of the offense are to be considered and appreciated in case of direct evidence. In case of circumstantial evidence, all the circumstances relied upon by the prosecution has to establish all the chain of events are so connected and proved that it is the accused who has committed the alleged offense. On the contrary, defense has to show that the circumstances have not been linked so as to point out the guilt of the accused. In the case of Sunil Colford, Daniel versus State of Punjab, reported in 2012, Part 11, SCC, page 205, it is observed that motive assumes great significance and importance in circumstantial evidence. Absence of motive would put court on its guard and cause it to scrutinize each piece of evidence very closely in order to ensure that suspicion, emotion, or conjecture do not take place of a proof. So, by virtue of this decision, certain, that is, cautions have been given to the judge while relying upon the importance of this, particularly the circumstantial evidence. In the case of State of UP versus Krishna Gopal and others, reported in 1988 Part 4 SCC page 302, it is observed that if there is conflict between the testimony of medical evidence and oral evidence, credible oral testimony has to be preferred and it has to be accepted. Generally, confession made before the police is not admissible, but under the VSA Act and Section 23 proviso, it is an exception to the general rule. Speaks about confession of the accused to the police to what extent may be proved. It says so much of information as relates to be proved with reference to discovery is concerned has been considered in the case of Antar Singh versus State of Rajasthan reported in AIR 2004 SCC 2865. The fact of which evidence is sought to be given must be relevant to the issue. The fact must have been discovered at the instance of the accused. Discovery must be in consequence of some information received from the accused and not by the accused himself. The person giving the information must be accused of an offense. He must be in custody of police. The discovery of fact received must be deposed. Only that portion of the information relates to distinctly and strictly to the discovered can be proved. So I pause for a while. So many times in criminal trials, so the entire statement of the accused is going to be marked. And so here, not only with reference to the discovery of this particularly the offense which has been used for the purpose of commission of the offense. So in this particular decision, so here it has been stated, so here that the discovery of fact received by the accused must be marked and that portion of the information relating to distinctly and strictly to be that is established in this particular regard. By going through the citation, it throws light on the fact that all the entities or pillars of the criminal jurisprudence while conducting the case has to take care of the fact that they owe a duty and it has to be discharged fairly and legally. If they are not going to discharge their duties fairly and legally, then injustice is going to be caused. In the modern trend, now digital evidence has to be considered with care and caution. Forensic evidence, medical evidence must also plays a very important role in proving the case, both parties and the proceedings. It is said that always burden of proof is on the prosecution. If facts are admitted by the accused, then the burden shifts on the accused to establish that under what circumstances the alleged offense has taken place. But in some cases, wherein the presumptions are there, then under such circumstances, initial burden of the prosecution, if it is established, it is sufficient. Thereafter, the burden shifts on the other side to disprove the same by preponderance of probabilities. In case of establishing preponderance of probabilities, strict proof is not necessary. In case the judge, the prosecution, defense lawyer must carefully see when the burden has been shifted on the accused and whether the burden has been shifted by the prosecution or not. It is all a question of fact. If he sleeps over his observations, then the balance will tilt against the accused. So that's why, so here that this balancing of the criminal trial, so here in at each stage of the case, so here that depends upon the prosecution, defense, and the judge. So here, if there is any mistake, then the miscarriage is going to be done. So another aspect at the criminal trial is recording of the statement of the accused under section 351, Code section 313. It is the statement of the accused after closure of the evidence of the prosecution for the purpose of enabling the accused to explain any circumstances appearing in the evidence against him, that a question is going to be put. The court need not give previous warning at the stage of the trial. Before accused is called on for his defense, no oath has to be administered. Accused is not liable to be punished or by refusing answers and not answering the questions, or if he gives a false answer. but the answer given by the accused can be used in other criminal cases. The court may take help of the prosecutor or the defense counsel in preparing the questionnaire. Court may permit to file the written statement. So here, in many cases, what we find, so here that it is considered to be a empty formality. In many citations of the Supreme Court and High Courts, that this particular that the aspect has been observed. Evidentiary value of the case statement of the accused has been discussed in the case of Sanatan Naskar and another versus State of West Bengal, reported in 2010 Part 8 SCC, page 249. Scope under this section is wide and it is not mere formality. Answers given are relevant for finding truth and examining veracity of the case of the prosecution, but it is not evidence. It can be used within permissible limits. While relying, it should not be considered in isolation, but in conjunction with the evidence of the prosecution. If accused fails to offer proper explanation with reference to the alleged circumstances, an adverse inference can be drawn against him. In another case, that is Rafiq Ahmad Ali versus Rafi, State of Uttar Pradesh, reported in 2011 Part 8 SCC, page 300. It is held that statement of the accused cannot be sole basis for the conviction. After taking the evidence of the prosecution and examining the accused and hearing both the side, if a judge considers that there is no evidence, he shall record the order of acquittal. The court must also remember that defective investigation will not be a ground for acquittal. If the accused is not acquitted, court may call upon the accused for his defense evidence. After defense evidence, court can hear both the parties and pass the judgment of acquittal or a conviction. If the accused is convicted for the alleged offense, court has to hear regarding sentence. Here it is very crucial while hearing this sentence. What the court has to do, what the advocate for the accused has to do, what the prosecution has to do has been very clearly stated in this particular. While imposing sentence against, the power balance has to be done by the court. Court has to see that sending the accused behind the bars is not the only remedy. Reformative method has to be adopted. The court has to strike a balance between the offense committed, what is the effect of the punishment on the society, victim, and it should also send a signal to the society that crime is not a business or making profit out of it. It is also the duty to impose proper punishment depending upon the degree of criminality and desirability to impose such punishment. It must remember that it is a means of deterring other potential offenders to commit such offense. This proposition of law has been also laid down by the Supreme Court in Sidram and others versus State of Karnataka, reported in AIR 2006 SC, page 3265, and in another case, Akram Khan versus State of West Bengal, reported in 2012 Part 1 Crimes, page 5. It is further held that sentence should not be sentence should be appropriate, befitting the crime. And in another case, Ankush Shivaji Gaikwad versus State of Maharashtra, reported in AIR 2013 SC, page 2454. It is observed that court has to hear the nature, the circumstances of the offense, background of the accused, the social background of the accused, economic and mental condition of the accused, prospect of rehabilitation, absence of mens rea, instigation and influence, delay in disposal of the case, state of health of the accused, gravity of the offense, whether accused is habituated or not, whether the offense has been well planned, etc. It also observed by the court that the court has to exercise the power and in appropriate case to award compensation to the victim or his relatives or the family members. It is also further observed that awarding compensation is a statutory duty of the courts. So here that in most of the cases, that they will impose a fine or that they will not pass any orders for the compensation to the victims or that is other the persons who have suffered in those crimes. It is also observed in many cases that there should not be plea bite sentence like punishing till rising of the court or only fine. The court must also see whether any minimum sentence has been prescribed. In the case of minimum sentence, the court has to impose that is minimum sentence. If the statute gives some discretion to the court, then under such circumstances, the court can exercise the discretion and give the lesser sentence than the minimum. Then if any clause is there that the judge has to be satisfied and impose minimum less than minimum sentence, then the discretion has to be exercised judicially with utmost care and caution. If the court imposes fine, in that event, default sentence must also follow. If the accused is convicted for 2 or more offences, he should also make it clear that whether the sentence for each offence should run concurrently or consequently. If the order is not clear, then under such circumstances, injustice is going to be caused to the accused. My friends, by going through the above aspects, if proper trial and proper punishment is to be given, the balancing of power in criminal trials from the beginning of the case, that it has to be started and that it has to go till the conclusion of the trial. In that light, the role of the judges, advocate, prosecutor, and investigator is very important. My friends, at the beginning, that I have started with the words in criminal trials, balancing the powers between the prosecution, the accused, and the judiciary is essential for the fair and just outcome. So, in that light, in order to come just that is outcome, that the duties so which has been prescribed by all these three entities, so they must balance it. So I have already referred the case of darshan. If there is any imbalance, then the check and balances are that is going to be that is checked by even the appellate courts or the superior courts. In that light, so here the very important aspect that which we have to keep in mind is power balance in criminal trial. So it plays a very important role on both conviction as well as acquittal. With the words of Mahatma Gandhi, I conclude my that is speech on this vital subject. I quote: "Live as if you were to die tomorrow. Learn as if you were to live forever." So here, that the learning process is considered to be a continuous process. Today, that we have learned something out of this, and we can go on learning and learning and learning. So here, so that we can learn as if we were live forever. Thank you for having given this opportunity to Vikas. Thank you, sir.
Thank you, sir. And rightly, Sushila ma'am had introduced to you, and you have just shared such an insightful session, and that too post independence. We are so glad that the role played between these three arms of the judicial system have been nicely explained to us. And we are so glad. Thank you, sir. And we will be in touch for a further session. Namaskar.